Now back to the show. This is The Law Show on CL 650.
Now there's a song we were talking about with our guests last time they were here, and we didn't find it. Our producer, Dwayne Bishop, found Lawyers in Love for this edition of The Law Show, featuring John Lakes and John White from Lakes White LLP in North Vancouver. We're talking estate planning, estate litigation, wills, and all those sorts of things. And with our guest, just before the break, we were talking about assets passing outside of the estate, and we got kind of sidetracked on life insurance, but it is an asset that passes outside of the estate. But John Lakes, you said, in addition to life insurance and RIFs and RSPs and TFSAs, there was something about life insurance that we didn't cover off.
Well,
so let's do that.
People should be aware that when they name beneficiaries life insurance, if they're young children, they should create a trust or refer it to their estate. Because, for example, the age of majority in British Columbia is 19.
Right.
However, to receive funds of a life insurance policy is actually 18. So if someone has, let's say, a $200,000 life insurance policy, it may be a single mother where she's named her 2 children as beneficiaries, and she dies when one's 17, they could get a check for $100,000 on their 18th birthday.
Right.
And that may not be really what's in the best interest. It might be better to either have a will, they make reference to life insurance policy where the life insurance is paid to the estate, so then the money is held in trust till the child is 25.
Right.
So the money's not blown. So generally life insurance is outside of the will, but you may want to have the estate as a beneficiary then, because then you can control how the life insurance money is spent under the will, and you don't have to worry about an 18-year-old blowing $100,000.
Well, let me pick another, perhaps a more obvious example, John. Suppose now that you've got a mother with leaving a couple $100,000 to a child, but and the mom dies, but the child is 6, not 16. What does the law do for that child or about that child and this sudden windfall for a 6-year-old? What do they do?
If there's no proper designation, the money's paid to the Public Guardian Trustee's office and will sit there till they're 19.
Oh, I see.
And there may be some arrangements that they pay out monthly for costs, and then if there's special costs such as braces or glasses, they may do with that. But the thing is, as soon as a child turns 19, all they have to do is show up at the Public Guardian Trustee's office.
And the balance of that is payable.
And they get the money, and and it could be a lot of money.
Right. Okay. So that's what happens if you don't have plans, if you don't sit down. Now, John Lakes was talking, Mr. White, about the organizing of one's estate and planning and all of that sort of thing. So, and you're the guy that goes to court. You're the guy that helps people fight their battles in court because in many cases, the plans weren't thorough enough. So when it comes time to allocating benefits outside of the will, as in an insurance policy or perhaps an RRSP, what other situations have you encountered in court where people just did something wrong in the first place?
Well, you know, I'm trying to think of a recent example, and I've got to say that at the end of the day, the court found that the person in question didn't do something wrong in the sense that they upheld what the court upheld what they figured this guy was trying to do. But what he did is he had 2 families. He had children from his first marriage who were adults by the time he passed away.
Right.
And then he remarried later.
So you have the second younger group.
And we have a much younger group who were still under the age of majority. And he split things up where he put the older kids on title to his house with him as joint tenants, and then left his estate, such as it was. He had a pension as well, which went to his younger kids, and left his estate in his will to the younger kids. Problem was, outside of the house and the pension, he really didn't own anything.
Oh, okay.
So
somebody got left a whole lot of nothing.
Well, I mean, the kids, the younger kids got the pension.
Right.
And they got a life insurance policy as well.
Okay.
So they were provided for in that way, even though they had this will that said they inherited this estate, which had basically nothing in it. But this gentleman left the house to his older children sort of through the back door by putting the older children on to the title as joint tenants. And at the end of the day, the court found, yeah, okay, I understand. The judge found that he could understand what the gentleman was trying to do,
what he was up to,
and upheld it.
Oh,
but
really? He did.
He upheld it in the end, but there were arguments that went either way. A lot of what we argued about in that case turned on what proof there was that the deceased gentleman really intended to give the house to his older children. And there were documents that he left behind that went either way.
Yeah.
So, what he left his descendants was a great big mess.
Right.
He could have done this a different way that would have been a lot clearer. And instead, we wound up in court for a day arguing about what it all meant.
Right. You mentioned he put the older children, put the house in a title with his children in an arrangement called joint tenancies.
Right.
And John Lakes, this is one of the items you wanted to bring to the table today to talk about joint tenancies.
Before we do, because I want to talk a little bit about what the pension, by the way he set up the pension, created a bit of a problem because
this is the money that went to the younger kids.
Yeah, because
ultimately.
It's a monthly pension.
Right.
And the pension is actually now being administered by the public guardian and trustee. So they're getting the check monthly, and then they're paying monies out to the children.
Okay.
But there's also some tax issues here because all of a sudden these kids have got an income, and they have to pay income tax on it. And as it gets older, it might make it difficult for them to have a student loan. And by doing it this way, from a tax point of view, was a very expensive way. I mean, he should have done a proper trust. And so the pension should have been paid to the trust, but he did everything on his own. So even with a pension, and people forget about a pension is taxable income.
Right.
And so when you name people that are beneficiaries of the pension, there is tax consequences. If there's a payout, for example, if you have a teacher who dies who's worked for 30 years, have never drawn on their pension, all of a sudden there's a payout of maybe $350,000.
Right.
And
taxable.
Well, if you give it to your spouse, it rolls over.
Okay.
But the problem is if you give it to other people, if it's not properly planned, all of a sudden there's a huge tax liability which could have been avoided. So these are things that are passed outside of the estate with people who haven't taken the tax consequence. RSPs and RIFs are the same thing. I mean, there's quite often with this, one of my clients, their biggest tax liability is an RSP where they may be sitting on $600,000. And if they haven't planned it properly, when they die, all of a sudden there's a $600,000 included within their income, which maybe they're paying up to 42% of that on the final tax return.
Straight to the feds. Yeah.
So, well, to the province too.
Oh, okay.
But it's something that when people do their planning, they don't always think of the consequences. They don't think of as long as it goes to their spouse, it's not usually an issue.
So would it be a safe take-home message from the program so far, gentlemen, to advise our listeners, if you plan on making children beneficiaries for any reason, that you should sit down and make an arrangement with a lawyer so that those children, underage children, under the age of what, 19, John?
19.
Yeah. So anybody who might be a recipient of your largesse after you're passing along, those arrangements should be made to be paid to that young person in trust. Right, John Lakes?
That's correct. And they should also talk to an accountant about it as well, too. Because, as I say, I mean, if you work for, a company with a pension, whether you're an RN or, through the health authority, whatever, these people don't really think of these pensions being worth much, but they can be worth a whole lot of money.
Right. Okay. So again, if you have minors in your life that might benefit from you, make sure that you talk to your lawyer about it before you assign any benefits.
Or a spendthrift 19-year-old, a spendthrift 22-year-old, or, an adult who's got mental or mental disabilities or
Right.
whatever. There's, every plan is unique, but too many people forget about about RSPs.
Sure.
And
Well,
life
and there's
insurance
certainly
and-
nothing
and-
wrong with the idea of passing along some loot to the next generation, or maybe a couple of generations removed, John White.
Well-
But again, do it properly, so there's no dispute. You're the guy who ends up with the disputes in your lap.
Well, that's right. I mean, it is so much better if you just take the time and, if necessary, pay the cost of getting some proper advice right at the beginning, rather than trying to do it yourself. I mean, if you really know everything of what you're doing, then by all means do it yourself. It's like building a house. You don't build a house by yourself without having some idea of what you're doing. You get some help.
Right.
This is building an estate plan. It's similar in many respects. There are things that a lot of people aren't going to consider, like the tax consequences
Right.
of passing along the pension plan in the way that they do, where they could be basically, no offense to our provincial and federal authorities, but they're throwing their money away.
Right. Sure.
Albeit into our tax system when they don't have to.
Right.
And so lawyers and accountants are there to advise people how best to structure their assets so that they don't have to pass off any more than necessary to the feds or to the province, and can send more to the people that they want
That
to
they
benefit.
wanted exactly right. We started sort of broached the subject of joint tenancies, John Lakes. What is it? And now, Mr. White defined a joint tenancy example whereby a person put his older children on title to his house. So what is that? What is that? It's called joint tenancy, but what does that mean?
Well, technically, it means more than one person owns this item 100%. So typical husband and wife, they own the house. They own, and if they'll have the term joint tenancy in the land titles, which says that when one of them dies, the other person files a death certificate and it goes to the survivor automatically.
Right.
And that was the law until March 30th, 2014. However, and so if you had the circumstances where people were killed together, so let's say a husband and wife are on a small airplane that crashes and you can't tell who died first.
Right.
Under the old law, the younger person was presumed to survive the older person. So let's say the wife is 2 years younger than the husband. Everything gone from the husband's estate to the wife's estate and all went through her estate.
Right.
Now under the new act, if people die within 5 days of each other or under circumstances as if they both died at the same time,
Right.
it's now presumed they both died each other. So that joint asset now instead would half would go through the wife's estate and half would go to the husband's estate. So joint tenancy only works if you survive the other person by 5 days.
Right.
Now, in all
Can I interrupt you for just one second? Because you've raised one little thing here that just caught my ear. You talk about the husband's and the wife's estate. Just to both of you, very quickly, how many, in terms of ballpark numbers, if husbands draw up a will and have an estate plan, how many of their wives are likely to also have a will and an estate plan, or is this mostly one of the two partners that usually does this?
No, they both should have.
I know they should have, but
no, they
in
usually
real life, do they both have them?
Well, I mean, if you've got a...
Is that right?
Yeah,
okay,
no,
I'm
they
impressed
usually
with
do.
that then. Okay.
Yeah.
I didn't think that was the case. I think I would thought, and certainly old school. I'm thinking my parents. My dad obviously had a will and everything was organized. He was a businessman. My mom never had a will. It just didn't come up. It wasn't something that it occurred to her. Now she does now. My dad's long gone. But I was just curious how many couples, John Lakes, do both husband and wife do the wills together? Is that typical?
Well, to do it together, if it's first marriage, yes. Sometimes, though, it's second or third marriages, they may do their will separately because they may have different beneficiaries.
True, right.
And they may also have an arrangement with each other that maybe they're not going to leave everything to each other. So quite often, second, third marriages, they'll have totally separate wills. I mean, there may be things like a trust set aside. But
so in the fall of 2015, more of us, men and women, equally are getting to the point where a will is part of the deal for being alive.
Well, we like to think so.
Okay.
And that's the way it should be.
Oh, and certainly I agree with that. I was just curious as to what the theory as it translates to reality, but you're suggesting that more and more people are getting on the ball as time goes on.
They all know they should have.
Sure.
Well, but the problem is there's lots of Mr. and Mrs. Shouldas out there who never actually do it. They say we should do it, but sometimes doing a will is not always a pleasant topic.
No, it isn't. No, when confronted with one's own mortality, one would rather go golfing than sit down with a lawyer, I think, just about any day of the week. Our guests in studio, John Lakes and John White from Lakes White, LLP. We're talking estate law, and we'll talk a lot more about joint tenancies after this quick timeout.
There's more of the show still ahead. This is The Law Show on CL 650.